Welcome everybody to the weekly webinar series that we're holding as a SCORE Monmouth. I hope you enjoyed our little introduction. My name's Claire Davids. I am a SCORE mentor and I'm here today to help facilitate through this call. I just want to let you guys know I'm not actually a panelist or an expert on the topic. I do have lots of opinions about lots of things though, so I will try to keep quiet and try and let John do his thing. Just to let you guys know a couple of housekeeping announcements before we get started. Each week we're having webinars with guest speakers to support our local businesses. So we have someone lined up for next week, and at the end of this webinar we'll announce that and give you a little bit of detail for next week. And we actually have a few speakers now lined up for the next few weeks coming. So stay tuned, keep a look at our Facebook page and our website, etc., and speak to your mentors if you have them. As you probably saw in the video, SCORE is a non-profit entity. We're offering free mentoring and webinar services and seminar services in different times to local businesses. We, on the call today, we represent the Monmouth County chapter, but this is a national organization and we're supported by the SBA. We're excited today to introduce John Murdoch of Zaker Fuchs to talk to us. He's going to talk about leases and contracts. And how to navigate those things both during and after the COVID situation we're in. So he's going to offer a wealth of knowledge to you guys. And I would encourage you, please ask questions and answers, or ask us questions and we will answer them. There's a Q&A function in Zoom. If you take a look on your screen, if you've logged on online, you'll see the Q&A function. If you could try to put those questions in the Q&A function and not into the chat function, that would be so much easier for us to moderate, and we'll really try to get through to every question. You can ask us questions anytime, just post them in the chat, and we'll, as John's speaking, if there's a relevant question as he's speaking, we'll do them, and if not, we'll do a Q&A at the end. So that's it, I'm done speaking for now. I will introduce John to you. He can tell you about himself and get into his presentation. Thanks everyone. John, take it away.
Great. Well, thank you so much. I am honored to be here with everybody today to discuss some of these issues and really want to focus on assessing small business contracts during the pandemic. There's going to be more of a focus on leases because that's probably one of the more big ticket items for a lot of small businesses. But what I talk about is going to apply generally to every type of contract that you may have. I can't thank SCORE enough for putting together this presentation. It's always an honor to present on behalf of SCORE. They have incredible resources. Now, what's going to happen is after the presentation's over, we'll be sending out a copy of my materials. I put together a little outline. I'll be speaking from today. You'll get a copy of those materials by email. At the end of the materials, you'll see I put some resources listing of the New Jersey governor's orders here in New Jersey that have been issued in connection with the pandemic. Recent legislation in New Jersey in connection with the pandemic, and some valuable links, including links to SCORE materials. Again, for small businesses, I can't urge you enough to go to the SCORE website and pull their resources and use them in your business. So again, they have incredible resources. Just to let you know real quickly, I'm a transactional regulatory compliance attorney. I've been practicing law for just about 20 years now. I've been through the financial crisis of 2008, 2009. So some of the things that are occurring happened back in that period of time, obviously with some differences. So some of what I'm going to be talking about is going to be sharing my experience from that time and just over my 20 years. I also was a fraud investigator for 7.5 years before becoming an attorney. And a lot of what I talk about is always influenced by my experience as a fraud investigator for the state. Just see my notes. I'm not going to talk about loopholes. I'm not going to talk about little tricks for you to try to get out of contractual obligations. I'm going to talk about the reality of the situation and how to best approach the various parties that you're contracted with in trying to deal with the problems you're facing, you know, the cash flow crisis, the burden of some of these contractual obligations, and some strategies on how to assess and how to deal with these obligations. First thing, I have to read a disclaimer. Obviously, as an attorney, I'm sure you expected it. The information provided in this presentation is for discussion purposes only and may not be considered legal advice. The information presented is a brief summary of selected contractual concepts as well as selected federal and state laws. Such selected concepts and other obligations must be carefully analyzed to determine the specific needs and legal obligations of the parties involved. Please consult with competent legal counsel to discuss the specific legal requirements for your matter. The intention of this presentation is to provide information to enable attendees to understand key principles and to comply with applicable laws and contractual obligations. Not meaning you can't try to change those contractual obligations, but no way to try to defeat, to try to trick or otherwise commit any type of fraud. I urge you to do the right thing. And we're not going to talk about employment law. We're not going to talk about loans from the SBA or any type of grants. We're really going to focus on general contract principles. So first, say is the amount of information that is coming at small business owners is overwhelming. Here, one of the shareholders of the law firm, Sacred Fuchs here in Red Bank, New Jersey, and as an attorney and as a business owner, it's overwhelming. I mean, sometimes the things are coming every day. Federal law changes, state law changes, local requirements. It's very, very difficult to be able to understand all the various things that have been going on. So don't feel bad if you feel overwhelmed. You should be. I know many attorneys who are overwhelmed. Many attorneys don't fully understand everything. So don't give you a little bit of comfort. You're not crazy if you don't fully understand everything that's going on. You're not abnormal. You're absolutely fine. Do the best that you can. And hopefully today we can clarify a few things. There's no set rules on how to handle your contractual obligations. But again, we're going to talk through some principles to help you to navigate. And the key phrase, it depends, is so true in the situation. It depends. It depends upon your business. It depends upon, let's say, if with a lease, who your landlord is. Is your landlord understanding? Is your landlord difficult? Do you have 1 month left on your lease? Do you have 9 years left on your lease? Who are the other tenants? There's so many factors involved. So each situation is highly unique. But throughout all of this, you, again, approaching it in the right way, and I'll explain, there's a philosophical reason to do everything correctly, but there's also a strategic reason for doing everything correctly, because as the smoke clears and maybe some disputes arise, you want to present yourself in the best situation to show, let's say you're before a judge, that you took the appropriate steps to try to do what you could. And so keep that in mind as we go through. And with that is to be proactive and do everything that's right. Let's see, first, there's a lot of myths going on out there. I've received so many calls from different individuals saying, well, I was told that if all the tenants in this one shopping plaza stop paying the landlord, there's nothing the landlord can do. And I go, that's not true. The landlord can go to evict all of you. So again, be careful of what people tell you, especially people who are non-attorneys, who want to feed their ego and try to give you advice that maybe that's just off the wall. So be very, very careful on that. And I get all kinds of crazy questions. There's myths out there that there's no way legally that you can be evicted as a small business. It's not true. In New Jersey, there's certain protections right now for residential tenants, and there's certain protections on mortgages for residences. But those types of protections don't apply here in New Jersey necessarily to businesses. So don't think that there's nothing that anybody could do and to force you to comply with your contractual obligations. There's no such protections. Now maybe, and there's some talk that there may be some protections that the state may try to put in place. Who knows if those are going to happen? Don't count on that happening. Position yourself in the best place possible to move forward with your contractual obligations. Also, as we talk a little bit more, an assumption I've made for today's presentation is that, again, this is given on behalf of SCORE, small businesses. You might not fully understand all the contracts you've entered into, and that's very normal. That's very common. A lot of times, especially small business with a lease, you take a look and see, all right, how long is the contract? What's my rent? And maybe some other key factors. Most people don't read through all these documents. It's always good to do it, But even if you do read through, sometimes you don't fully understand what a lot of these terms mean until you had some experience, and that's just a difficult part of life. So again, just if you're feeling a little overwhelmed, not understanding what you can do, what you can't do, and hopefully what we talk about will help you navigate through some of these issues. I'm also making an assumption that most of you don't have business interruption insurance. I point that out because one of the things, I'll give a few other pointers at the end of the presentation, is you should check to see if you have business interruption insurance. Good chance if you do have business interruption insurance, it probably won't provide the relief that you hope for, but you need to check. That's a whole nother seminar topic, but again, for the attendees of today's presentation, I didn't think it was appropriate to spend too much time there because I think most of you probably don't have that type of insurance. And again, it's kind of complex whether it applies or whether you would actually get some benefits or not, because it's not only a pandemic, but most of the businesses are not shut down necessarily because of the pandemic, but because the government has ordered you to be shut down. So that's where some of these issues come into to play. All right, so what is your first objective in taking a look at what you need to do going forward with your contractual obligations? First is list all your contractual obligations. We did this as a law firm. We sat down and we took a look. What are all our obligations, written or verbal? If you have an obligation, you have a contract, you want to assess where you are. You want to identify the obligations in the contracts. Again, I'm going to talk primarily about leases, but you think about each contract and what the obligations are. There may be payment obligations. There may be services that you need to provide to your customers. You may have services that are supposed to be provided to you. So again, you want to have an understanding of what your contractual obligations are, and then basically assess where do you want to go first. Again, leases are usually one of the big ticket items for some small businesses. That's a good place to start and looking at ways of trying to see if you can maybe cut back on some of your financial obligations, maybe delay them. We'll talk a little bit more about that. But there may be other big ticket items. Some of your, let's say you have contracts with key employees, with independent contractors. You want to take a look at these as well. And again, understand all the contractual obligations, what your obligations are, and the obligations that should be that you should be receiving as far as services, etc. Identify the term in each contract. How long are you in this contract? So if you're sitting there as a small business, you've been shut down, cash has basically stopped coming in the door. So you're looking at all your obligations. So you take a look, again, you list them out and take a look at the term of each contract. So let's say you have a fairly big ticket contract, but it's month to month. All right, well, you have the obligation to satisfy the obligation currently, but if you can terminate with a month's notice, all right, you kind of know how you can approach that contract. That's not going to be the case with something like a lease typically. Typically, a lease is going to be a much longer term, but you want to find out how much longer you have within that lease. Are you looking at 3 months left in the lease before possibly a renewal at the end of the term? Are you looking at another 4 years? You're looking at another 9 years. You want to know what position you are. That's going to help you when you speak with the other party. And in the case of lease, when you're speaking with the landlord about what to do with the contract. Now, with contracts, again, leases, this is not usually the case. But with other contracts, you'll have, let's say, a term, whether it's a year, 3 years, 5 years, whatever it may be. But take a look at the ability to terminate. Many contracts, especially service agreements, will have a provision that either party can terminate for bad conduct. And also, a lot of contracts have provisions that either party can terminate without cause, which means that, so let's say you have a contract to provide services to a customer, but let's say in that contract, let's say 5 years, but in that contract, either party can terminate without cause upon, let's say, 60 days notice. It's really a 60-day contract. Either one of you can get out with 60 days notice. You need to know that because if you can have the ability to terminate upon 60 days notice, maybe you'll want out of the contract, but you'll know what the the ability to get out of it by either party, and that can help your ability to negotiate possibly better terms on that contract. Because in that case, you may say to the other party, all right, listen, don't want to do this, but you know what's going on with the pandemic. We're not making it. The contract says we can terminate 60 days without cause. We don't want to terminate. Again, this is just kind of a hypothetical situation, but we'd love to continue on these new terms. This is what we can live with. And that puts you in a much better place if you understand that ability to terminate the contract on those terms. Now, not every contract has it. And as you go through these, don't feel upset, angry because maybe contracts don't have some of these terms. That just may be the deal that was struck, and not every contract has this, but you want to know if that exists in an agreement.
Hey, John.
Yeah, sure.
We've had a question come in, and it just, I think it may be a little bit, it may be relevant. But a question, what qualifies as an obligation? So, and I think then a little more clarification to that was, if you do, I mean, so you have a written contract, obviously that's an obligation, but what if you have an email with a contractor or with a customer that says, we agree to do this, or that they agree to do that? Could that be considered an obligation? Is that something, because a lot of times, especially with small businesses, I think, I mean, I know in my past, I've been guilty of it, you know, a handshake agreement or a, you know, a signature on a cocktail napkin or an email or a text. And can that be used and considered an obligation, or is that, is it truly contracts that would, you know, would be enforceable?
That's a fantastic question. And boy, if I could have fed someone a question, that would have been the question, because it's absolutely great. Yeah, so in this connection, when I'm talking about obligations, I'm talking about contracts, any type of agreement. And yes, anything, you can have a binding contract, whether or not it's in writing. So you mentioned like a handshake deal. Unless there's a specific statute, some type of law that says a contract has to be in writing, you can have an enforceable agreement between two parties. The problem is always, what are the terms of the agreement? So if two people meet and they say, all right, I'll sell you my boat for $100. The other person says, perfect, I'll buy your boat for $100. You shake on it, you have a contract. But what are all the terms? You know, when is the closing going to occur? Is it tomorrow? Is it next week? So that's always a problem with verbal agreements. But absolutely, absent some type of law, and the big law that's typically requires a contract to be in writing is it's under the statute of frauds, is for real estate transactions. So typically a court will not enforce a verbal agreement to sell real estate, but unless it's in writing. But what does that writing mean? And just kind of what was just brought up is, yeah, if you have an exchange of emails, we're going to provide such and such services for $100 if you would like us to come over and do it next week. And the person says, absolutely, come over and perform the services. You have a binding agreement. Again, the details of what's going to happen is very vague because those things are not set forth in writing, but you do have an obligation. Now, in a case like that, which always makes it tough is, yeah, exactly what are the obligations? Can you terminate, etc.? That becomes a case-by-case basis we have to look at. But when you're assessing all of your obligations, you want to take a look at those. And one thing may be in your assessment is, well, I have these verbal agreements. I need to reach out and see if we can modify and maybe say we're just unable to perform until maybe a month or two from now. But that's a great question.
Perfect, thank you.
Oh, thank you.
And just whilst you go back to your, I see some other questions coming in, so that's great. We will answer them all. So keep them coming in the Q&A function. And John, go ahead. Sorry if I interrupted.
That was fantastic. So we talked about the ability of the term, to identify the term, the ability to terminate. Also take a look in the contracts, things that might be beneficial. So let's say you have a contract to provide services, and we had an issue, a matter here, where part of the contract was to provide drivers to go into New York City. I don't want to go into details on the contractual obligation, but the supplier of those drivers had a problem because the driver said, we're not going to New York City with everything that's going on. So, you know, when I say identify obligations, not only the financial, but also do you have to provide certain services. But take a look in your contracts as far as what else may be at play. we talked about the ability to terminate, but think about, for example, for a lease, what might be available as a way to help you navigate a resolution with your landlord? Again, cash flow is stopped, you owe rent, you don't have the money, but what may be in the lease? For example, security deposit. Can you approach the landlord? And leases almost always say that you cannot use a security deposit for rent payment. But maybe now's the time to talk about that. And some landlords have been granting that. If you have a sophisticated lease that provides, that's a triple net lease, a lot of times you pay a base amount of rent. Let's say it's the base rent, plus you pay your proportionate share of the landlord's real estate taxes, the landlord's insurance, and their common area maintenance costs. And within those common area maintenance costs sometimes is a reserve to be able to pay for people to plow the snow. There have been some landlords who have actually approached their tenants and said, listen, we had hardly any money spent this past winter for snow removal. We're going to basically give back some of the monies we've accumulated in reserves to offset some of the rent obligations. So you take a look there. Is there anything in the lease that maybe puts you in a position to help negotiate with the landlord? For example, again, don't be upset if your leases don't have these. These are pretty sophisticated, but for pretty sophisticated leases, but giving you ideas on things to take a look for. If you're in a strip mall and let's say there's an anchor tenant, sometimes you can get a provision that if the anchor tenant is closed or goes out of business, your rent can be reduced because of the loss of the flow of foot traffic from that anchor tenant. So let's say you're a gift card store and you're next to a big food store. You might have a provision in your lease that if that food store goes out of business, your rent may go down by 30%. So you want to take a look if there's anything in those agreements that might be helpful to you. You also want to think about, as you're considering all these issues, which one of your agreements have personal guarantees? And the reason I say that is, as you're looking to negotiate with these parties, and unfortunately I've had clients, I've had this discussion, hopefully your business will make it past this and make it through the hurdle, but not to be too cavalier about saying, well, if things go bad, I'm just going to close up. That's the end of my business. Meanwhile, maybe you have personal guarantees on certain obligations that exposes you personally for the obligations of your business. So the big one is typically leases. It's pretty unusual for a small business to have entered into a lease within the past 5 to 8 years to not have a personal guarantee. So being aware of what that personal guarantee exists is also going to help you make decisions regarding your entire business as far as, going forward. Can you make it past the hurdle? What would be the impact if you did have to close up? It may not be the end exposure to you financially if there's a personal guarantee. So again, you want to make sure that you understand that. So having done that assessment, you want to find out, can your, we'll talk more about a lease, but can your payment obligations either be forgiven? Can they be delayed? Can they somehow be modified? And again, from 2008, 2009, I worked with a lot of clients who modified their leases in order to kind of achieve those results. Now, with all this goes outside of some of the legal issues. You start thinking about what kind of tenant you have been and what kind of landlord you have. If you've been a wonderful tenant who's always paid your rent, has never been a problem, you're going to be in a much better position being proactive, approaching the landlord and trying to work out a resolution versus a tenant who's always difficult, always complaining, and maybe the landlord would love to see them removed. I'll give you one example. One of my clients, actually such a good client, goes above and beyond. The landlord approached them and said, we know what's going on with the pandemic. Don't worry about April's rent. It was pretty phenomenal. They're a great tenant. We've had other clients, the landlords, they're chomping at the bit. They can't wait to see them fail because they hate the people who run the business. So again, you want to understand, and if you have a bad relationship, try to foster it at least now. So going back to with the payment obligation, so again, the example of a lease, let's say you gather up your information, you understand what your obligations are, you understand also what the finances are for your business, because be prepared. You approach a landlord and you say you want an abatement of rent, you want modifications. A landlord is well positioned to request to see copies of your books and records to understand what's going on, the reality of the situation. So I gave this example yesterday. Once a month, because of your business, you're able to fly to France for dinner. Don't expect the landlord to be overly sympathetic if they believe there's a lot of cash available. But if you're able to have, organized books and records ready, I'm not saying to offer them up, just be prepared for the landlord to request copies of certain information. But if you're able to demonstrate the harm, obviously, your business is closed, the cash flow is not coming in. But certain types of businesses, I know some of my clients, they have some of their businesses online. So they're still making business, they're still making sales, even though maybe their storefront is closed. So be prepared for approaching, let's say, a landlord in this case, in order basically kind of to plead your case and offer up a solution. Now, understand what's going to happen. You approach, let's say, again, a landlord and say, obviously, what's going on. Our business has been closed. We don't have any money. First thing the landlord is going to say is, we have bills to pay too. We have a mortgage. We have our real estate taxes. We have our insurance. We have all the maintenance charges. We need the money from you to pay those. Absolutely. You let the landlord know that this may be life or death for your business. And what you're trying to do is stay in business and not go out of business within the next couple of months. Sometimes that's what landlords need to hear, and it's been successful when I've been helping some of my clients, is, again, their knee-jerk reaction. They want all their money because they have bills, but when they stop to think about it, and many of them are thinking about it a little bit more now the past couple of weeks, they don't want to lose you as a tenant. If you've been a tenant and they're paying, they don't want to lose you. So, and this is something to understand. Again, you don't start throwing this in their face and say, well, you this, and this, because that you want it to be very cooperative. But understand, from the landlord's position, this is going to be a tough time for a lot of businesses. They might not be able to fill that space with another tenant in the next few months. So if your business wasn't able to survive, that landlord cannot necessarily quickly fulfill that space. And a lot depends upon your type of business, what's in there, what the build out, the location, etc.
So, John, I have a couple of questions that might be relevant to this as well. What can you do if you don't have any income coming in, you're closed, and your landlord isn't willing to work with you? And perhaps, that was a question that was asked by Bill, but perhaps just adding to that, and you have a personal guarantee on your lease. So you have no money coming in, you have no income, your landlord is not being flexible, not being accommodating for whatever reasons, and you have a personal guarantee on the lease, then what happens?
Great question. Unfortunately, a lot of businesses are in this situation. So whoever asks the question, you're not alone. Again, you want to be proactive, and it sounds like the person who asked the question is being proactive. You want to document you're being proactive. Again, you do it in a nice way. You have an email address, want to follow up, want to discuss, what's going on. You'd be very, very nice. When you write these types of emails, if you're doing letters to the landlord, you're not only doing it for the landlord, let's say in this case with a lease, you're also doing it if you're ever before a judge. So you want to do the right thing always, but you also want to present before a judge. Let's say if it got to that point, if it was going to be evicted, or if there was any other issue, you always write as if somebody, as a judge is going to be reviewing it, someone else is going to be reviewing what you're doing. You want to cast yourself in the best possible light that you can. So you do the right thing, you be respectful, you request it, but then getting to the heart of the question, what do you do? Let's say your business is forced to shut down, you have a personal guarantee. Well, you're exposed. The landlord is free to come after you. There's unless something changes in the law, there's no protections against a landlord from suing you for the amount of rent. Now, just so you understand, standard personal guarantees on a lease are typically, absolute guarantees for the entire length of the term, meaning you owe the money for the rent, plus any other costs related to the landlord taking action. What do I mean by that? If the landlord had to sue you, the landlord can sue for the unpaid rent, plus they can sue for the cost of suing you to collect those monies. They can sue for a broker fee to try to get another tenant in there. Now, a landlord has an obligation to try to mitigate the damage, trying to get another tenant in there. And if they did get another tenant in there was paying the rent, well, the amount that that new tenant is paying for the balance of your term should come off of what you owe the landlord, because again, they have a duty to mitigate the damages. They're not just supposed to leave the space vacant. But yeah, if it's a personal guarantee, they can fully go after you for the balance of those monies. Some landlords will not pursue, some will. So it really depends on the landlord. I've been in meetings with pretty sophisticated landlords who have joked that personal guarantees really don't mean anything, because if the person doesn't have any money, they don't have any assets, what's the point of spending the money to sue them and get nothing? So a lot of sophisticated landlords will really hesitate sometimes to go the full distance with suing. Some know, right, the moment you're late, you're going to get those threatening notices. So it really depends on the landlord.
And then another question, kind of, I think in the same vein, is if you're a tenant in a mall and the mall is locked down, can it be argued that your space is untenable, entitling the lessee to a rent abatement?
Great question. And actually, the one thing, now this is going to be in the handout that's going to go out to everybody. I just want to share, I wanted to make this more of a conversation than just showing a lot of slides today, but I do want to show a provision. Now this is a standard provision in most leases, and this goes to the question that was asked. And actually, there's probably two parts of that question. One is, if I understand it correctly, is basically you're forced to shut down. Are you expected to pay rent? Well, a lot of leases, a lot of contracts as well, but not as many as leases. This is a pretty standard provision for a sophisticated lease, force majeure. And you can see it up on the screen. I'll read it out to anybody who maybe is just dialed in by phone. If either party here too, again, this is a lease, is delayed or hindered in or prevented from the performance of any obligation required under this lease by reason of strikes, lockouts, labor troubles, inability to procure materials, loss or interruption of power, restrictive governmental laws or regulations, which arguably in this case would be would apply. Arguably, the language isn't super clear. Court order, riots, insurrection, war, military or use of power, sabotage, severe weather, fire, or other casualty, but not including insufficient insurance proceeds, financial inability or lack of financing of a like nature beyond the reasonable control of such delayed party, collectively and individually force majeure, the time for performance of such obligations shall be extended for the period of delay. But in leases, a standard provision to that is, notwithstanding the foregoing, any event defined as force majeure shall not excuse tenant from the prompt and timely payment of rent when due under this lease. So force majeure provides that if for some reason beyond a party's control arises, you might not be able to perform your services. So let's say you have a landscaping business and it's nonstop rain for 30 days. All right, if you have a force majeure provision, probably excused from providing the services during that 30 days. It's beyond your control. This comes up a lot with construction companies, etc. But again, so going back with a lease, you could argue under language like this or something, similar language, and this I pulled out of a lease I just seen recently. You could argue, hey, the government forced us to shut down. It was beyond our control. The force majeure provision should allow us basically to extend our obligation to comply. But typically with leases, they're not going to allow you to get off the hook for paying rent. Now, but again, this is a provision you should take a look in your contract to see if it helps you or not. And again, I love the question coming at this time, because that was one of my next things to go over. So you want to understand this is, does your contract even provide it? And not every lease has it. Some of the shorter commercial leases for small businesses, they don't always have this in there.
So I think So what I think, just to paraphrase more, probably because I want to understand better, is if you have a force majeure thing in your contract, then it may well, in terms of the shopping mall, which is closed down, it may well be something that you'd be able to use.
Probably not, because in just about every lease,
Okay.
in the force majeure provisions, they usually have that that exception for rent. Usually, so where this, and it was funny because right before everything broke, it's the first time in 20 years that I rewrote a force majeure provision. It wasn't that big of an issue. It was broad enough. Usually, you felt fine. What was in there, but I put in specific language about the COVID-19 and certain delays. Now, this would probably excuse you from, let's say you're a tenant, you just signed the lease, and now you have to build out the location, but you can't get in there. Your contractors are not allowed to be in their building. This would allow you to extend the time to comply with the build out, but it wouldn't stop the obligation to pay rent. So that would be damaging. Now, force majeure provision under another contract may be very good. So it may give you something to argue that you're not obligated to comply with the terms of the contract because of force majeure. Going back to the example briefly, I was talking about a company providing the drivers. It was one of the things that was discussed is, wait, we have certain restrictions. We can't provide the drivers because of everything that's going on. But because of the language in the force majeure provision of the contract, it wasn't super clear whether it applied or not. But again, it's something you can take a look to see if maybe you have some type of defense. But yeah, generally, I've never seen a lease that has that provision that doesn't carve out the payment of rent.
Okay, thank you.
Okay, let's see.
So just a quick time check. It's 3:38. So I think for your presentation time check, and we have a couple more questions. So I'll let you keep going, and then we'll add in the questions.
Fantastic, because I always typically run over, but I know I can't run over today, which is great. We have, because I could talk about this all day. So we're talking about, so now you approach the other party, you're looking to extend your obligation to perform under the agreement. And again, we'll talk about a lease. So let's say you approach the landlord, say, please give me some relief. One approach may be, all right, landlord comes back and says, well, we got to pay our expenses. We got to pay the mortgage. We got to pay this. We got to pay that. Say, all right, let us cover those expenses, but the difference, let us extend and build into the contract, the lease payments over time. Or maybe would be even better. Those, let's say maybe April and May's rent is forgiven. That's fantastic if you can get it. Is it perhaps you load up the lease with the payment obligations for the balance of the term? So let's say your rent payment is $10,000. Well, maybe you add on $250 for every month's rent beginning in June, or whatever it may be, whatever can be worked out. With all these, you want to have, going back to, I guess, the question about being in writing, you want to have something in writing. Typically, these are usually one-page documents, maybe 2 pages, to memorialize what's occurred. And just, so for example, if the landlord says, all right, don't worry about April's rent, you really want to have something in writing. Listen, if you're dealing informally and you have a great relationship with the landlord, and the landlord sends you an email, don't worry about April's rent, you're probably in good place. I wouldn't be necessarily hitting them with a very detailed lease amendment and getting it notarized. That may send the wrong signal. But in that, again, each case is different. You'd have to talk with a competent attorney about it. But you don't want to be annoying, especially if they're giving you a gift. But you do want to document what's agreed to. So typically, again, you have a one-page amendment. It identifies the parties. It identifies the lease that has been entered into. And it provides what exactly the parties have agreed to. As far as either delaying the rent payment, how it's going to be paid over time, the forgiveness of rent, whatever it is. But you do want to make sure you document it. But as we're talking through all these things, also bear in mind is before you modify any contractual obligations, is there any legal requirement restricting you from doing it? So for example, healthcare facilities, they're required to provide certain services. So if, let's say, if you were a healthcare facility, you can't just stop the provision of laundry services, of dietary services. You couldn't let go of your director of nursing. That would be a violation of law. So even though contractually you may have some flexibility, you might not be able to do that from a regulatory perspective. So make sure you understand what your obligations may be and how you may need to modify those. Let's see. I guess we were talking before about approaching the landlord. I want to wrap it up pretty soon because to make sure we have enough time for questions. Is I mentioned, identifying all the obligations, understanding where you are, putting, having your information together as far as your financials, if the landlord is going to request those, and being able to make the best argument possible. I mentioned that going forward, the landlord is going to be considering what do they do if you close up shop? If you go out of business, what kind of tenant are they going to get? And to understand some things with that, your type of business. I know I have some people on here, which I'm honored to have participating today, is a bunch of owners of dojos from around the country, Aikido dojos, and again, very honored that they're here. So there's certain Aikido dojos, it's a martial art. Some of them run real lean and mean, and it's not so hard for them to move to another place. There's some that are very detailed, ornate, which would be very hard to move. So you have to understand your ability to be able to relocate the business if something happened. And also for the landlord's perspective. So if you are, let's say, at a key location, let's say you're a hair salon, you have a key location, how is that landlord going to rent out that space to someone else? So let's say, and this is what the landlord's thinking, if this business shuts its doors forever, and I can't get any money out of them, even maybe there's a personal guarantee, but maybe the person becomes bankrupt, what am I going to do with that space? Who can I get in there? And if it's going to go to someone who's not, let's say, a hair nail salon, I've got to rip out everything to get it ready for a new tenant, or I have to give, most likely, a huge tenant allowance to rebuild out that space. These are things that the landlords are looking at. So be thinking about, before you talk, again, through focusing a lot on landlords, think about from their perspective, what it's going to cost them if you're not there. They want you there. A lot of landlords have financing their mortgages that require a certain percentage of space to be rented. So that may affect their financing. They may actually have obligations under that financing. There could be certain defaults under the financing if they lose those tenants. They really want, generally, the same landlords. They want those tenants in there. They want them paying rent. So really use this, again, not to outmaneuver anybody, but both sides have a legitimate goal. You want to keep your business there. You want to survive. They want to survive. So thinking about that perspective as you approach your negotiations with them. And then,
well, that's interesting. So we had a question from Mallory. I just got this landlord response after asking for 50% rent reduction for 3 months. And it wasn't very reassuring. They said, we are not ready at this time to make any firm decisions regarding rent abatement requests. We were waiting to see how this situation evolves. How would you handle something like that? That's kind of, I mean, I read that as a non-answer, right? That's the landlord not really giving an answer at all, just kind of, kicking the can down the road. What would you do with something like that?
and what was the response again?
We are not ready at this time to make any firm decisions regarding rent abatement requests. We are waiting to see how this situation evolves.
Okay, sure. And that's it's funny because a lot of landlords are in that position because the last thing they want to do is, especially, fairly large landlords, they don't want to give anything across the board because it's a ton of money that they're going to be out. Keep the relationship. Stay proactive. You can't force it. So if you have a contractual obligation, you're bound by that contract. good or bad. So if the contract requires, so again, $10,000 of rent each month, your business is obligated to it. You may have a personal guarantee on top of that. But again, keep the open line of communication. Be the tenant that they want to hear from, but be prepared to make your argument. And one of the things to really consider is whether your business can survive by paying the full rent. But think about this also. If someone had to close its shop, so let's say you're operating as a ABC company, it's a retail business. Your ABC company, you decide to close your doors. Let's say there's no personal guarantee on the lease. You decide to close your doors. You close up that location. Then you move across the street, XYZ company, basically doing the same thing. Landlord can come after you. Even though there's no personal guarantee, you set up a brand new company, but basically you're still in business. So what you tried to do is you basically said, well, one company's out of business, but you open up somewhere else, you've got some problems. The landlord finds out about it, they're going to come after you. So not so easy to be able to get out of the situation. And again, I'm oversimplifying a lot because there's a lot of strategies in doing certain things. But what I'm trying to say is right now is do your best you can to be able to present your case to the landlord. Understand that they might not want to be talking with you, but be ready with your information, pursue it, and be ready to show that, hey, this is what our revenues are. We've lost this. We're not going to be able to make it. We're going to have to close. They may say, well, then fine. Then we'll see you. Well, that's unfortunate. We hate this. We hate to see this, but this is how it's going to be. But again,
what you're sort of saying is make every effort to show that you have done everything you can to do the right thing, given the current situation. Because if it does become litigious, if it does end up becoming more than, something you can negotiate with your landlord, if you can demonstrate that you have done everything in a way that was not just really trying to get one over on the landlord, that will that will be helpful for you if it becomes more down the road.
Absolutely. It's interesting because I was just talking to one of my partners here who does landlord-tenant work, and he brought up a very good point. Exactly what you just said is just, let's say a landlord went to evict a commercial tenant, say, well, non-payment of rent, there's no protections in New Jersey for that non-payment for commercial tenants. We want them evicted. Now you're before a judge. And the judge starts taking a look at the evidence as a tenant. You say, well, Your Honor, obviously you're aware of what happened with the pandemic. Basically cash stopped coming in the door. We approached the landlord. We did this, this, and this. That's going to present you in a certain light. So again, you're always thinking about whatever you do may be scrutinized later. You want to be the party that's done everything right. So it may very well help you out. The speculation is that with landlord-tenant court, they're going to be overloaded in several months when everything lifts. And there's going to be an increase in the mediation program. So again, you want to be able to walk in, whether it's a mediator before a judge, presenting your case as favorable as possible. But I find with the landlords too, again, some landlords are crazy. You can't negotiate with them. But some, again, they want those tenants to survive. So again, you just want to be proactive and be respectful.
And then I have a couple of other questions that are here. So we have Rosemary has asked, this is back to the business continuity insurance, and her coverage was denied as an act of God, and it's also limited to building and personal property. Can she appeal that?
You can. That's pretty complex. She should, if she wants, reach out to someone who specializes in that. I could maybe try to refer her to someone. What's difficult is you have different types of insurance coverage covering different types of losses. So you have certain types of coverage maybe only protecting some of your hard assets. You have business interruption insurance that may, let's just say for argument's sake, maybe applies for a certain situation. Let's say maybe a pandemic, but the business is not necessarily closed because of pandemic, but it's because of governmental orders. It's a complex situation. There's a lot of litigation out there across the country over this. So again, that's probably a presentation for several hours. But with anybody has follow-up questions, shoot me an email and either try to help you out or try to point you in the right direction. But it's a complex issue.
Great. Okay, then we have another question from Deanna. My current lease is up the beginning of 2021. I'm a good standing tenant and my business was mandated as closed. I want to see how everything works out once we can open again. How far in advance do you need to negotiate a new lease?
Oh, great question. It depends. Now take a look at your lease and see. So I'm assuming it's going to be for the same landlord. So if there's a renewal provision, you want to make sure you notify the landlord well in advance. A lot of leases, and again, everything I've been talking about is solely here in New Jersey law, is that sometimes you have provisions in leases. Let's say it's a renewal. You want to make sure you get everything resolved before that deadline, because if you don't, you go past. For example, some leases say if you want to renew your lease, you have to notify the landlord at least 180 days in advance. If you don't do it, it's almost like you have no renewal rights left. So you got to make sure you do it in advance. But now's a great time. So let's say that there's no renewal option. It's just a negotiation. One thing I want to stress, and I'm hoping to maybe do another SCORE presentation on this in the future, but is if things really get bad in the economy and there's a lot of businesses that don't make it, the thing I said about personal guarantees, that's a big thing to think about. One is, start looking to negotiate well in advance, because it depends upon your business, whoever asks the question, as far as finding a place, negotiating a lease, building out, etc. But also start thinking about the different position you're going to be in. Back in 2008, 2009, a lot of my clients who entered into leases didn't have to sign personal guarantees. Landlords were desperate to get tenants in, and a lot of times they were willing to take the risk. You weren't going to make it. They wanted to fill the space. They wanted the rent. And again, a lot of my clients got in without personal guarantees. 2010, that started changing. They wanted those personal guarantees again because they had enough tenants in there to be able to feel comfortable. So yeah, absolutely. It's a great question. Always be looking in advance. And if you have you're working with a current landlord, start working now to see the best terms you get. But make sure you don't blow any deadlines, but be thinking about what the landscape is going to look like. Because in several months, now if everything goes back to the way it was a few months ago, all right, that's one thing. If there's a lot of places that are closed up, put you in a much stronger position as a tenant to negotiate good terms. And if you've been in business for a while, you look great. You made it, again, if a lot of businesses close, you stay in business, you're a good looking tenant for a landlord.
And then I think the last question, and then we'll have to wrap it up, is Mallory has asked, what about asking for your last month deposit to be used for a current month of rent right now?
Yeah, and that touches upon what I mentioned briefly. Take a look what you may have in the agreement, because typically in all those leases, they always say you cannot use that security deposit for your rent, but you can ask for it. Some landlords have offered that up, so you can absolutely ask for it. Landlords don't like to do that. They want to have something to go after if someone defaults at the end of the lease, especially if there's issues with the premises, there's damage, etc. There's nothing wrong with asking for it. And maybe one of the options may be is, hey, can we use this money now to satisfy the rent and allow us to replenish it over the remainder of the lease, or replenish it over the next 6 months, year, whatever it is. But have that discussion, and that's absolutely a great thing to take a look at.
Wonderful. So I think if we, John, you have a presentation, right? A Word doc that you have created. So
That's
for all
correct.
So for everybody who's attended today, we will send you a copy of that document, and it's got some good information. John shared the force majeure stuff, but there's also some other good items of information in there as well. So please, check your emails for that. Also, just so everybody knows, we are going to be live streaming these meetings on Facebook going forward as well. So for anybody who didn't have a chance to register or wants to go back and look at anything they may have missed in the Facebook feed, go ahead and do so. We'll post this on our YouTube channel. I want to thank John ever so much for your time and your presentation. That was great. Really, really useful, helpful stuff, especially in these times, and even to think about as we move forward and start to negotiate leases. I think the real estate world will probably be changing. So it's good to stay on top of all those types of things. Next week we have, just checking my notes, sorry. Next week we have Deborah Smith presenting. Deborah Smith is a social media expert. She owns a social media marketing and content development company in Monmouth County. She's also the founder of jerseybites.com. So she will be presenting on how to manage your social media content and networking throughout these times we're in COVID, and also after that. So please sign up for that. It's going to be on our Facebook page. It will be on Eventbrite. It will be on Meetup. And I think after, if I've done it correctly, at least, if after we terminate this meeting, it will take you straight to the registration page for that. So I would love to see you guys all come back for that next week as well. John, do you have any final closing comments?
You're going to see a copy of the materials I put together. Quite a bit of it is a listing of some of the recent New Jersey statutes, governor's orders here in New Jersey. So you'll see how overwhelming a lot of the stuff is, but there's some good links in there to help you. And the first links I bring you to, direct you to, is to SCORE. Again, I can't urge you strongly enough to go to the SCORE website. They have incredible information, and it's geared for probably everybody who's attended this presentation. And it's an absolute honor. And I just wanted to share my experience with people over the 20 years and trying to get some of the best results for your business. And I wish everybody, best of health, safety, and success.
Thank you so much, John. I don't think I can top that. So I'm going to say thanks ever so much to everybody for attending, and hopefully we will see you here same time next week. Thanks, guys.